I am Chris Irons, Strata consultant, Hines Legal, former Commissioner for Body Corporate and Community Management. With me, as always, Frank Higginson, partner, Hines Legal. Frank, welcome, or should I say aloha?
Aloha. Yeah, no, it's the kangaroos and cricket bats. Spring's here, so is cricket season. Hello, everyone. Hello, Chris. A very exciting Body Corporate Record conversation.
Indeed. Thanks, everyone, for joining us on Thursday. Look, in all seriousness, we always do really appreciate everybody attending. We know that there are plenty of other things that you could be doing with your time, so thanks for making the effort, everybody. As always, if you have a question, particularly if you've got a bit more of an involved question, better off putting it into this link that we're just about to put up there on screen. You can fire us off a question and we'll get back to you as soon as we can. Please feel free to put questions up live today and we'll try and get through as many of those as we possibly can. Today, though, Body Corporate Records 101. Fair to say, Frank, from my time as Commissioner, it was just about the most inquired about, disputed about thing that the Commissioner's Office dealt with. I think it continues to be that way, give or take a few topics. Because it's such a big issue, we're going to cover this off probably over a series of webinars. So today, everybody, Frank, perhaps we're being a bit ambitious, but today we're going to try and cover off some of the fundamentals around what is a record, the body corporate role, he says, trying to get in the actual camera, and costs. So we're going to try and cover off those three big topics today. In part 2 of this series, we're going to try and move on to who can access, how can records requests be refused, what to do if there's a missing record, and is there such a thing as vexatious records requests? That'll be a good one. So stay tuned for part 2 very soon. But today, records, Frank, fundamental issue. Why? Why is it so fundamental?
Well, I suppose, like for me, one of the analogies I always use for bodies, corporates and committees is the committee's like a board of directors of a company. You know, and all of the shareholders are the lot owners. The committees are the directors, or the committee members are the directors, and it's their job to sort of make decisions, albeit for the benefit or in the best interests or reasonably in relation to all of those lot owners. But inevitably, you're never going to please all of the people all of the time. And so very often there's, I want to know why or how or what, and people get twitchy about being accountable, you know, from a committee side of things. So, and certainly one of Chris's little sidelines is helping committees usually who are feeling a bit defensive about what they are going to give to owners. But there's a real onus, I think, in relation to records and the legislation on transparency and accountability. And that means that they're available to the owners, because ultimately the owners are contributing their proportionate share of the levies, and that's where some of that money is going towards the maintenance of those records, so they're entitled to them. But there's lots of fights.
Sorry, Frank, I was just going to say, yeah, everyone just remember that model, that in the body corporate, you're all part of a collective, and if you're going to be part of a collective, then it all needs to be transparent, otherwise it doesn't work. So that's how body corporate records are kind of legislatively, he says, structured: transparency, openness. And so many times, Frank, we have people come to us at a webinar or a seminar or a client and is aggrieved about something that's going on in their body corporate, and they can't quite figure out why, or they can't quite figure out what. The one thing that usually helps them to clarify what they're aggrieved about is a record. It's that document which establishes here is what has happened, or indeed here is what not has happened. Isn't that right?
Absolutely. And one of the things really, and the default, the question for most people in terms of refusal of allowing people or seeking to, and we'll talk about a decision which is really relevant in this in a minute, if you're not going to give access to the records or not going to deliver something that someone's requested, why not?
Right.
And as always, we don't like them. We are frightened that they might have a go at us about it. They're not valid reasons to refuse access to records.
But have you got hired? That's the question, isn't it? If you are reluctant to hand over a record, my first comment would be, well, what have you got to hide? You must. And from the point of view of the other party, that's immediately what they're going to think. If I'm an owner who's denied a records request, first thing I'm going to be thinking is, well, you're concealing something from me.
It's a massive red flag.
Yeah, absolutely. Let's rip into it, Frank. Let's go. First up, what is a record? Well, there is actually some definition around it. So we're just about to put up a link now. Section 231 of the standard module. That link will be appearing at the moment. But Frank, in summary, what is it? Rather, what is it not?
Well, I think probably it's some things. Oh, crikey! I'm going back to statutory interpretation, which dead set was probably 1992 in my law degree. But they talk about definitions being inclusive or exclusive, or sort of following on in a sense. So you might say a consumable in a management rights agreement might be fertilizers, chemicals, or other such items. So in that you sort of follow on. When you look at what section 231 of the module, the standard module we'll put up that Chris has done, that's really mirrored in all of the other ones, and you go through what's in there, really the best way I'd describe it is it's everything that comes into the possession or control of the body corporate relating to the body corporate affairs. That would probably be the most global way. So documents, notices, correspondence in and out, minutes, emails relating to those minutes, agreements with lot owners, bylaws, management rights agreements, orders made, submissions, the whole box and dice. And that's all part of what is, I suppose you'd almost call it the corporate affairs of the body corporate. We talk about the body corporate being a business. The same as, I suppose, we as a law firm have a whole bunch of records, financial and otherwise. Body corporate's no different. And the difference, I think, with a body corporate and why this becomes really important is that in a law firm sense, I'm still here as I was 20 years ago, so I tend to remember some things. In a body corporate sense, committee members come and go, body corporate managers come and go, and so that organic knowledge can disappear year on year. So the record keeping becomes really, really important.
That's a great point, Frank. It's that stored knowledge, so that regardless of whether you're buying a lot now or you're buying a lot in 10 years' time, the record of how things have transpired at that scheme remains untouched and kept centrally. So I think that's an excellent point, Frank. The question comes up from time to time, an exchange of emails between committee members about body corporate business. We reckon that's a body corporate record, I think.
In relation to committee business, yes. And again, I suppose we've got to be a little bit careful, as much as we like being black and white about these things. There's some grey that can apply to these things. So, and one of those things was in what context was the email sent? Was it in relation to a body corporate business, or was it incidental to it, or was it just a sideline and it really was a personal thing? I'm inviting Chris over for a beer on Saturday afternoon to watch the footy. They can balance out a little bit.
But if at the end of that email inviting to the footy, you say to me, oh, and by the way, I vote yes on that motion, on those motions, that's absolutely a body corporate record at that point. I had a couple of questions in recent times about posts on Facebook page. So you might have a body corporate that has a Facebook page set up for everybody to sort of put up maintenance requests. And similarly, the idea about a text message sent from a body corporate chairperson to a caretaker about an instruction, for example, or a maintenance job. Would they be records? That hasn't really been litigated an awful lot, but I have to say, Frank, I reckon it's yes, isn't it?
Yeah. I'd say so. It's in relation to the affairs of the body corporate.
Yep. Question from Peter, because I think this is actually the next point we were going to make. Thanks, Peter. If a body corporate manager has not downloaded from the body corporate bank the monthly bank statement, is the bank statement nonetheless a record, and is an owner entitled to request and be provided a copy of the statement? It's an interesting one for me. My initial reaction would be the record hasn't been created yet.
Yeah. So if it's not in the possession of the body corporate, it's not necessarily a record of the body corporate at that point in time, as much as it could be requested. So it's a bit of a characterization one that, in that sense. And I suppose, what's an analogy? Analogy might be that we've sent out a vote outside committee to make a decision. We haven't got the responses back yet. Those responses, before they arrive, aren't body corporate records, but when they do, they are. That's probably as quick as I can do on the hop. So
the other point I'd make about it, Frank, is that would be the initial reaction. If it's taking an awfully long time to download that statement, be it deliberately or otherwise, I would start to ask questions at that point about, well, what's the issue and what's going on there at that stage.
And everyone gets twitchy about money, don't they? You know, you're from full stop, end of story, and it's sort of if it's because again, that red flag. Again, Peter, if it's not being done for any reason other than disorganisation or the bank's ability to download it is down, why not? What is there trying to hide?
Yeah. So we'd say probably it's not a record just at that point, Peter, but that's a really good question. I just want to go to one final point, and we've got a few more questions to go there. I know there's been an adjudicator's order not that long ago where somebody asked for a record which was basically already in the public domain. So something which was on a register, like a set of bylaws. And the argument from the committee was, well, you can go and get that from the titles office. But that is still a record if it's in the body corporate's possession, isn't it, Frank?
The fact you can get it from somewhere else doesn't mean it's not a record of the body corporate to which a person legitimately entitled to it is.
Yep. We'll get to, Roy, thanks for your question. We will get to that one, but we're going to move on to, and that's a very, very, very short and sharp overview of what is a record. There are a few subsets of that one, which we'll cover off in coming weeks, I can assure you.
But I think we're back to, if you don't think it's a record, why not?
Yeah.
That's the default position. It has to be that it's more about transparency than anything else.
Yep.
So if you don't want to include it, why not?
It's an exception-based thing, isn't it, Frank?
Yep.
I think, definitely.
Yep.
Let's go on to one of our favourite topics, Frank, the role. Now, here's a fun fact for you. I think I did a seminar when I was commissioner, and I was doing my research as I usually do. The word role comes from, I think, the Old French or the Old Latin, and the exact word was rollus, which means constant motion, I think, or words to that effect. So when you think about it, it makes total sense, doesn't it? The role is a dynamic document. It is constantly being refreshed and updated. It's an essential record. It's, I think, Frank, arguably the most essential record in a body corporate. Would you agree?
Agree. And it's certainly something that's not necessarily capable of being created from other sources. So example, you're missing your bylaws, I go to a search of the CMS, $40 later, I've got it. But you can't go and recreate people's contact details and phone numbers and now email addresses, the date they purchased and all that sort of stuff. So it's a very vital part of body corporate record keeping and the means to access and contact all of the people who you actually need to access and contact.
Because remember, they are members of your community. You will need to be in touch with them at some point. So the role is available to what's called an interested person. And that's a pretty wide-ranging definition. And we're going to expand upon this idea of who is entitled to access a bit more. But let's just say that an interested person can be pretty wide-ranging. I'll share a story with everybody. I have been, and I still am, a tenant in a community title scheme, an occupier. And there was one occasion when I had to ask for a copy of the roll because I needed to get in touch with the owner of the neighbouring apartment because of some noise problems I was experiencing. I was given a copy of the roll because I was an interested person. An interested person, Frank, can be almost anybody. But I guess the point we're trying to make there is that not only is the roll widely available, but there is this very, very strongly held misconception that privacy laws override provision of the roll. But Frank, big furphy, isn't it?
Yep, absolutely not. So if you're an interested person with legitimate entitlement to get access to the body corporate records, that includes the roll, and that includes everyone's contact details, email addresses that are now actually part of it after our new module started in March, and everything else that's on it. So, and even an interested person, there's fairly wide-ranging definition. But the other thing is that at the end of the day, it's anyone authorised by an owner. So an owner can say, go and have a look, and you can go and have a look. So, and Chris, I think there's a decision there that you're about to put up, in which I suppose a committee in this one was trying to deny another potential would-be committee member access to the roll for the purposes of lobbying owners for voting at the AGM, and the adjudicator. It's actually a really good decision in terms of, you'd say, access to roll and body corporate records 101, links to sections, explanation as to why, and very black and white. There's no grey about that one in terms of Doesn't matter that they might be trying to have a crack at your position. They're entitled to the role. They're an owner. They're an interested person. End of story.
And so for the committee to say you can't have a copy of it because we're concerned for privacy or because we don't know what you're going to use it for, that's another one that's used quite a bit. It doesn't matter. For body corporate managers watching this one, I know that this is a pretty sensitive issue for you because you will have in some cases quite legitimate concerns about who is trying to obtain a copy of the role and for what purpose. The bottom line again remains the same. You or your committee can't use that, privacy laws make it such that we cannot provide it to you. It's that order that we've just posted makes it abundantly clear that is not
and
the case.
You can't deliver it on the condition you don't use it for this, or you can't refuse to deliver it because someone might do the wrong thing with it. The wrong thing, I suppose, of course, is very subjective, and to the extent that there was something actual criminal or unlawful, I'm not sure what that might be, then there's consequences for that, but they're not for the body corporate to necessarily pursue. That might be a police matter or otherwise. So it's the role, it's there.
We're just putting up a link to an article that we have written in the past on that one, which goes into the role in just a bit more detail. One of the important points about the role, Frank, which I think government's really going to have to turn its mind to sooner rather than later, is there is not only are there no privacy laws which apply to the role, there's no way to redact or conceal on the role either. So once your details are on there, you can't then say to the committee, can I please remove my name? Can I please conceal it for whatever reason? Even a reason, well,
I can do that. I can do that for an electoral role.
You can,
can't I? But I can't do it body corporate wise.
No, you can't.
There you go.
No.
We're all learning things today.
Well, the issue has come up in relation to the new residential tenancy laws, which may or may not be debated today in Parliament. We'll see. Where there's been big focus on tenants escaping DV situations, as there should be. But a tenant who has a lease of 6 months or more must have their details on the roll. So if you've got a tenant who's escaping a DV situation, technically their details have to be made public on the roll. That situation has not been addressed by legislation. It's probably something that's going to have to be looked at, I think, in the near future. But for now, there's no way to just blot it out or keep it silent. It's a funny one, isn't it, Frank? Well, not funny. It's something that needs to be addressed.
Well, yeah, and they talk about bodies corporates being the fourth layer of government. So I suppose in a sense there might be some government style, I suppose, restrictions, obligations, accountability imposed with respect to them in terms of people's personal safety. So yeah, okay.
Let's get to a couple of questions, Frank, before we go on to our final topic. From Roy. Roy, thank you. If an SMS from chairman to caretaker is a record, what extent is he supposed to go to in order to record? Is he supposed to print out and pay his manager to file?
Good question. Well, to me, I suppose it is a body corporate record. We're going to talk in part 2 about this and what happens if there's records that are missing. I could probably categorically guarantee you that there's going to be 1,000 text messages between people that aren't forming part of body corporate records that quite possibly could be. And I suppose if you want best practice on that one, to me, that would be not sending text messages, but sending emails. Emails with a CC to the body corporate manager. It's automatically then, hopefully, saved into the body corporate records and away you go.
Or having a verbal conversation if you really must.
Which aren't body corporate records.
Well, that's right. John, thank you for your question. John, that's a bit of an involved question that you've got there, not necessarily about records and quite detailed. Can I ask you to please put your details in that link right at the top of today and send us through a few more bits of information?
We do lots of marina berth work for bodies corporate, so pretty sure we can help with that.
Yep. David, thanks for your question. Can you explain the difference between general meeting and committee meeting? Not really a records question, but we can knock that one over pretty quickly. Committee, there's no obligation on how many times a committee must meet, but it's a meeting of only the committee members. General meeting, all owners, minimum 1 per year. And every owner, assuming they're financial, gets to vote. Alex, very quickly, who is responsible for maintaining the list of owners? The body corporate, the committee. is responsible for that.
And normally that'll in effect be outsourced or contracted out to the body corporate manager that the body corporate's engaged, who'll do it via their software, manually or otherwise.
That's right. But equally, Alex, it is up to the owners and occupiers to keep that information current as it happens. Let's get to our final topic, and we might have to whiz through this one relatively quickly, Frank. Costs.
In accessing records, yeah.
It's always about the moolah, isn't it? So, interesting point number one, committee members are entitled to records at no cost with some reasonable limits applying. It's basically a fair use policy, isn't it, Frank?
Yeah, you're on the committee. You're entitled to get access to the body corporate records without paying for it, I suppose, in a sense, to fulfil your duties and your obligations, the double check and whatever it is that you might be. And for, I suppose, both Chris and I, if you've got a management rights owner at your building, they're automatically elected a non-voting member of the committee. And as much as we haven't found an adjudication on this point, we think they're committee members for the purposes of that section as well.
Yep. That's what we think anyway. The fee is prescribed by regulation, and we're just chucking up those fees now from the Commissioner's Office website. The fee is an interesting one, Frank, because it is based upon how many pages of records it is. But what happens if you don't know, Frank?
I think best practice, and actually certainly has been covered by litigation, is you've got to send in more than what you think it will be and get a refund later. So the way the fee is, it's whatever it is, $18 or $35 lot owner or other lot owner, and then 65 cents a page for photocopying. So if you think you're going to have a big lumpy amount come back, maybe send in $200 and get the refund, but don't be sending in a, hey, I'd like the records, can you please invoice me afterwards? Because that's actually not a compliant request. Must pay in advance.
Definitely. There's no capacity to waive fees either for access to records. I've certainly heard of instances where somebody wants a record and then doesn't want to pay for it. Sorry, legislation says you have to cough up, so cough up you must. A lot of questions come up about other charges in relation to records. So the body corporate manager and their time spent. So let's just say an owner has made a huge records request, and you can count the number of pages and the fee per page applies. What happens, Frank, if it takes the body corporate management firm 50 person hours to compile that information?
Well, there's a bunch of people who are going to be pulling their hair out to start with, but leaving that aside, there's a difference between the cost to access the records, which is payable by the lot owner pursuant to the regulations, and the cost to deliver the records or deliver that or fulfill that request. They're two different things. So what the owner has to pay is that statutory amount and the cents per page. If the body corporate manager has to spend 50 hours going through the records to compile all of the information relating to fire safety over the last 5 years, say that's the extent of our request, they've absolutely and should be, under the terms of their agreement, charging the body corporate for the provision of those services, but those costs can't be passed on to the lot owner. They're two different things.
Although they will be passed on to the lot owner eventually, because they'll have to pay for it out of their levies.
Their proportionate share, but it won't be a direct cost to the lot owner to get access to the records. So, and the same, it came up, and this got litigated a little while ago in the Commissioner's Office in terms of charging for votes outside committee. So an owner makes a specific request. Body corporate says, well, that's going to cost $300 to send a VOC. You must pay that to us before we send the request. No. The way it works is an owner's entitled to make, particularly now, an owner's entitled to make a request to the committee. The committee's got to give effect to that. And so it's not dissimilar. So there's the statutory costs, and then there's the delivery costs, which are the other side. They're two different things.
Speaking of statutory costs, Frank, there's no prescribed fees for things like CCTV footage, USB downloads, or any kind of virtual records. Let's call them a virtual record. That poses a bit of a problem, I guess, because if somebody rocks up and wants, 24 hours worth of footage, how on earth are you going to calculate that? I suppose if you were going to print particular frames, you could do it that way, but rarely does anyone want to print a frame of footage. Having said all of that, there are a couple of adjudicators' orders which have gone into this issue and have said that the reasonable cost recovery can be made on that sort of thing. So we're going to put up one order now, which delves into that one a bit more. Again, it's something that government's going to have to turn its mind to, Frank, isn't it?
It is, yeah. And previously, when someone's asked for a window, where it's certainly gone once or twice, 4 hours worth of time, I want this, make it available to them. Here's the 4 hours. You can scroll through that and see whatever it is that you want to see.
It's the easier option, isn't it?
Yeah.
That cost thing, that cost issue, cost for accessing record is one where I think a lot of people come unstuck in the process. We are rapidly running out of time. We want to cover off a few best practice issues before we finish up today, Frank, but a couple of questions have come through from TJ. TJ, thanks for tuning in. Who is responsible to notify the body corporate of the change of ownership?
The owner. So there's a BCCM Form 8 that really includes all of those details, corporate nominees, proxies, tenants, all that sort of stuff. It's the owner of the lot, or the new owner of the lot, I suppose, in a sense, and normally their conveyancing lawyer would hopefully do that.
Indeed. Louise, thank you for tuning in. Can a screenshot of a WhatsApp be used to record a vote, such as a committee engaging a lawyer?
Well, I suppose there's two things. There's the WhatsApp itself, and I suppose the WA Liberals have got this going on at the moment, don't they, with all of their exchanges? What I'd say is the conversation around WhatsApp, again, back to emails and texts, probably is a body corporate record, but ultimately a decision to engage a lawyer by VOC should then still be formally done from a body corporate manager's perspective and communicated to owners and form part of the record. So the voting on it, in that sense, might be different from the decision itself to record that it's been given effect.
Yep.
So as long as the decision's there, then that's probably 90% of the battle.
Yep. Roy has posed a point about CCTV and privacy. Fantastic point, Roy. It comes up all the time. We will be covering CCTV in part 2 or even part 3.
Well, keep you hanging on that one, Roy.
Stay tuned, Roy. Gleno, I know you're a regular. Thanks for tuning in. If a non-committee member is given the complete body corporate records on a thumb drive, I'm not really sure why that would happen, but anyway, greater than 5,000 pages, what should be the costs? Should be 5,000 times 65 cents.
Well, I don't know if there's no photocopying involved. Here's your, yeah. Oh,
that order I've just put up before, Frank, goes into that issue. So, Gleno, have a look at that last order that we put up. There is some discussion there about that sort of thing. But if you're talking about per page copies, it's a different story. But it does go in. That does go into a bit of detail about the thumb drive. That one. That's a good question. We haven't been able to answer everything today. We've obviously got more parts to this one. But Frank, some general best practice, because we always love to leave people with best practice, don't we?
We do.
What do we reckon number one is?
Legislation's pretty hardcore on transparency and accountability here. So if you're not going to follow, if you're going to actually not, from a committee perspective, hand over or give access to information, you've got to be real careful about it.
Yep.
If not, why not? It's all about transparency and accountability. And in a sense, not in a sense, people's investments.
That's right. Follow the process, whether you're the person asking for it or the person handing over the record, because there is a process there.
Yep.
Another best practice point, and I know this for a fact, adjudicators take a very dim view of disputes about records where it's pretty clear that the record should have been handed over and wasn't. So don't waste everyone's time and money by letting it get to that point, and you also don't want to risk an adverse finding, let's put it that way. Those adjudicators have sharp tongues, Frank. And finally, if you're an interested person, you need to remember that if you're making a huge and unfettered records request, you ultimately will end up paying for it via your levies, won't you? So just what's that old expression, Frank? Check yourself. Check yourself on this one.
Nice rap music.
Do you need 20,000 pages of records? Really? Do you need? You might think that you need every financial statement that's been created in the last 30 years at the scheme, but do you really? And if you do really think that you need that, then just remember someone has to pay for that somewhere ultimately. everyone pays in the end. Thank you, everybody, for tuning in today. This is clearly a big topic. Don't forget, next time we're going to cover in part 2, he says, scrolling rapidly up to his notes to remember what we are going to cover next time.
Refusing access, what you're not entitled to, vexatious requests, CCTV, Roy, and those sort of things. Absolutely. Because it's probably
to do with missing records. Yeah.
Yes. Yeah. Some of the detail, the other things we get on these things, when we started with this, it's sort of, there's so much content. Here's the sort of 101, then we'll get into some of the more common fights.
Absolutely. But next week, one of your favourite topics, Frank, and the start of a new series next week, the CMS series. Everything you always wanted to know about a community management statement, but were afraid to ask. So we're going to kick off the series next week with a bit of a discussion about entitlements, maybe a few amalgamations chucked in there for good measure, a few other bits and pieces. CMS is, we were talking today about records. CMS is the establishing record of a body corporate. So make sure you tune in for
Very
that one.
first document.
Yep. For now, though, Frank, thank you.
Thank you, Chris. Thank you, everyone, for joining us again. See you next week.
We really appreciate it. Thanks, everyone.